To bless the 22nd Bicara Persada, we start with Kitab Al-Fatiha. Bismillahirrahmanirrahim. Alhamdulillah Rabbil Alamin. Ar-Rahmanirrahim. Maliki yawmiddin. Iyyaka na'budu wa iyyaka nasta'in. Ihdinas siratal mustaqim. Siratal ladzina an'amta 'alaihim ghairil maghdubi 'alaihim waladdallin. Yang berbahagia, Profesor Datin Nur Azia Haji Muhammad Awal, Official Representative of the Vice Chancellor, University Kebangsaan Malaysia, Your Excellencies and distinguished guests, ladies and gentlemen. On behalf of University, once again, let me welcome all the distinguished guests to University Kebangsaan Malaysia. Today we have the pleasure of hosting three distinguished panelists, Mr. Stephen Mathias, Sir Michael Wood, and His Excellency Professor Rahmat Mohamad at the Persada Canselori, for them to share their opinions and views on the role and the relevance of the United Nations and international law in the 21st century. Distinguished guests, ladies and gentlemen, without further ado, let us invite our moderator for this 22nd Bicara Persada, Professor Dr. Rashila, to conduct the discussion. Please welcome, Professor.
Thank you very much. Professor Datin Nur Azia, our Deputy Vice Chancellor for Student Affairs, Ambassador from the Philippines, as well as from Ghana, and representatives from the different embassies, distinguished panelists from whom we will be hearing shortly. And ladies and gentlemen, I noticed there are quite a few of our graduate students from the Defense College, as well as I believe the Institute for Diplomacy and Foreign Relations. So thank you very much for coming to the program this afternoon. Considering it's Friday afternoon at 3 o'clock, I really applaud all of you for being here this afternoon. Okay, let's give everybody a quick round. Today's topic, as you can see, the role of United Nations and international law in the 21st century. Still relevant? Okay, this is the thing that we're going to talk about. United Nations is an organization that will be celebrating its 70th birthday, okay? And it was formed in 1946. Now this is 2015, right? And through the years, it has accomplished a lot of things, but at the same time, there have been also people questioning of its function, okay? There are those who said that it is too bureaucratic, it's too huge. Can we find anybody in the system? Well, we do have our Assistant Secretary General of the UN here, okay? So we can find people. Okay, now, but the UN has also done a lot of things. It is the best place for mediation. It is the focal for any military intervention that we need to make. And this year, for the next, Malaysia is a member of the Security Council. So this is the time that, we can make some impact. So I'm not going to take too much time in the introduction here, because I'm quite sure you would like to hear from our distinguished, each of you, okay? And then we will go into the forum, right? Now, on my immediate left is Mr. Stephen Mathias. Now, Mr. Stephen Mathias, as I say, is the Assistant Secretary General for Legal Affairs of the United Nations. Before joining the UN, he had 23 years of experience in international law. He served at the United States Department for 20 years, including as Assistant Legal Advisor for the United Nations Affairs. Now, from 1992 to 1996, Mr. Mathias was the Counselor of Legal Affairs at the United States Embassy at The Hague, where the focus of his work was the International Court of Justice and the startup phase of the International Criminal Tribunal for the former Yugoslavia. Yeah? And from 2004 until 2007, he served as the General Counsel for the Multinational Force and Observers, which supervises the implementation of the Security Annex to the peace treaty between Egypt and Israel. Before joining the public sector, Mr. Mathias worked from 1981 to 87 in the private legal practice. He was educated at Georgetown University and Columbia Law School, where he first studied for a Bachelor of Science in Foreign Service and then as a Juris Doctor. And as I said, he is now the Assistant Secretary General for Legal Affairs of the United Nations. So let's give a round of applause for our first speaker. Thank you for having. Okay, I'll go and make the introduction real quick, okay? We must know all our speakers first. Okay, right in the middle, right there, Sir Michael Wood. Sir Michael Wood is a member of the UN International Law Commission. Yes, he was the principal legal advisor to the Foreign and Commonwealth Office between 1999 and 2006. During 35 years, as a lawyer in the FCO, he attended many international conferences, including the United Nations Conference on the Law of the Sea. Okay, that is another contentious issue that we have here in our region. Anyway, Prof. He did spend 3 years at the United Kingdom mission to the United Nations in New York, dealing chiefly with Security Council matters. He was agent for the United Kingdom for a number of years before the European Commission and the Court of Human Rights, and UK agent in cases before the ICJ, as well as in proceedings before the International Tribunal for the Law of the Sea and arbitral tribunals. So Sir Michael Wood is the Special Rapporteur of the United Nations International Law Commission. So let's give him a round of applause. Welcome, Sir Michael. And finally, with us, to my extreme left, is Professor Dr. Rahmat Mohamad, Secretary General of the Asian African Legal Consultative Organization, better known as ALCO. Professor Dr. Rahmat Mohamad is the 5th Secretary General of the Asian African Legal Consultative Organization. He was appointed on 20th of June 2008 at ALCO's 47th annual session in New Delhi, India, and unanimously reappointed for his second, third, and final 4th term in 2012. Yeah? During this time, Professor Rahmat continued to see the fruition of the work he had begun as Secretary General of ALCO in the quest to revitalize the organization in the promotion of the codification, dissemination, and development of international law, and in ensuring that the Asian African perspective is heard and heeded in the international community as regards to the progressive development of international law. So, Professor Rahmat, for you. All right. So with that round of introduction, now I'm going to give the floor to Mr. Mathias for his, to begin the dialogue this afternoon. Thank you.
Good. Well, thank you very much for that introduction. Deputy Vice Chancellor, Excellencies, ladies and gentlemen. First, I want to thank UKM and the Institute of Malaysia and International Studies for the invitation to be here this afternoon. It's a great pleasure to be here. This is my first time in Malaysia. In my initial intervention here, I'm going to divide my comments into two parts. In the first part, I'm going to describe a little bit the ways in which the United Nations, during its first 70 years of existence, have contributed to the development of international law in the post-World War II world. And then in the second part, I'm going to try to answer the question whether the United Nations and international law are still relevant, that provocative question that's been established for our discussion today. But first, I think to inform the discussion, it would be useful to give a brief survey of the way in which the United Nations has contributed to the international legal system as we have it today. So I think the first and most important contribution of the United Nations to the international legal regime is the development of the multilateral treaty regime. So from the outset of the UN's work, nearly 70 years ago, the member states of the UN have emphasized the crucial importance of an international treaty framework, which is comprehensive, robust, open, and transparent. And this commitment comes from the preamble to the UN Charter, which speaks about a collective resolve to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained. Now, since 1945, the number of multilateral treaties adopted under the auspices of the United Nations has grown exponentially, and today there are more than 560 multilateral treaties that are deposited with the Secretary General in New York. The subject matters governed by these treaties cover almost every area of activity of the United Nations. And over the years, the actors involved in the negotiation of the treaties have become more diverse, and the negotiators themselves have increasingly become expert as the complexity of the treaties have grown. Non-governmental actors also increasingly play an important role in treaty negotiations. Article 102 of the UN Charter requires that every treaty and international agreement that is entered into by any member state has to be registered with the Secretariat, and it is published in the UN Treaty Series. That collection now has over 2,600 volumes, and it constitutes the most authoritative reference on international treaty making. Now, in performing the depository functions of the Secretary General, as well as the registration and publication of treaties under Article 102 of the UN Charter, the treaty section within the Office of Legal Affairs, where I work, has leveraged new technologies to provide authoritative treaty information to member states as quickly and accurately as possible. Now, another important contribution of the United Nations to the development of international law is the work of the International Court of Justice. Now, of course, in the international legal system, there is no centralized international legislature, which makes the jurisprudence of the International Court particularly significant in the development of the law. Through the process of confirming or developing the relevant rules of international law applicable to the particular cases before the court has an important impact on the development of international law. And the court's judgments and its advisory opinions serve as a material source of law, and it is a locus to which states and other actors look for evidence of the rules of international law. I'm now going to mention briefly the intergovernmental organs of the United Nations, the General Assembly and the Security Council, the principal ones. So the universal organ, if I can put it that way, of the United Nations is the General Assembly. And over the 70 years of its existence, the General Assembly has considered a very wide range of topics. While much of this work has been undertaken at the political level, such activities have often led to the further development of international rules in different ways. In some cases, this has been a direct development, such as when the General Assembly has adopted treaties or convened diplomatic conferences to negotiate and adopt treaties, and also when it has adopted major proclamations of principle, which are often called declarations. The contribution of the General Assembly to the development of international law has sometimes also been more indirect, either by way of providing general policy guidance or procedurally by establishing processes or subsidiary bodies to consider the legal aspect of specific issues. Now, the General Assembly's contribution to the development of legal norms has spanned a broad range of subjects. Its focus has been on the maintenance of international peace and security, and that has involved major pronouncements on aspects of peace, security, friendly relations among states, disarmament, peacekeeping and other operations, the peaceful settlement of disputes, and the responsibility to protect. And the Assembly has also adopted instruments relating to national sovereignty and non-intervention, the rule of law, and aspects of statehood. The General Assembly was at the forefront of the development of contemporary international human rights law through the adoption of several important declarations. It has also been active in the area of international humanitarian law, refugees and humanitarian assistance, criminal law, including international terrorism, drug trafficking, crime prevention, corruption, and international criminal law, and international trade law. It has also contributed significantly to the development of rules relating to territory, the sea, outer space, and the environment generally. In short, the body of treaty-based law that I mentioned earlier is complemented by a larger number of non-binding rules and statements of principle that have been adopted collectively by member states acting through the General Assembly. Now, the second intergovernmental body that I'm going to mention is the Security Council. I'm sure you're all familiar with its work. It has also been important in the development of international legal rules. The Council has the primary responsibility under the UN Charter for the maintenance of international peace and security. While its mandate is thus narrower than that of the General Assembly, its powers are greater, including the power to take binding decisions, and it has used this power to strengthen international law in various ways. Invoking Chapter 7 of the Charter of the United Nations, the Security Council has condemned violations of international law. It has imposed sanctions on wrongdoing states and non-state actors. It has created and continuously adapted the institution of United Nations peacekeeping, which is not mentioned in the Charter, but has proven to be an indispensable tool in resolving international and internal armed conflicts. In recent years, the Security Council has begun to develop a normative framework on the protection of civilians in armed conflict, including aspects of international humanitarian law, human rights law, and refugee law. The Security Council's resolutions on the protection of civilians in armed conflict illustrate a shift in its focus from state security to human security, which has been prompted by a broader understanding of what constitutes a threat to international peace and security. And the Security Council has also adopted resolutions on women, peace and security, children in armed conflict, the protection of humanitarian personnel, and recently even the protection of journalists. The international rule of law has always been an important theme in the Security Council's activities. And this is demonstrated in part by its establishment of the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda, both of which contributed to the momentum which led to the adoption of the Rome Statute of the International Criminal Court, and hence to the creation of a more permanent institutional architecture in the fight against impunity. It has recently also taken a more proactive stance by invoking the responsibility to protect civilian populations from massive human rights atrocities, thereby further developing the applicable norms of international law. Now, I wanted to share that brief survey of the United Nations work in contributing the international legal framework with you before coming squarely to the question that has been set for this afternoon's panel. That is the United Nations still relevant, and is the international legal framework that it has helped create still relevant? And I see that this question in my mind it becomes relevant in a way because of what I would describe as a paradox in the state of the world as we sit here this afternoon. On one hand, we are told that today more people are living longer in better health, with better education, better sanitation, a better standard of living than at any other time in human history. At the same time, however, people hardly know where to begin in describing all the problems that the world is facing. On the global level, there is a prospect of catastrophic climate change, the ever-increasing wealth and income gap between the wealthy and the poor, the rise of international terror. There is the threat of deadly disease spreading internationally. In many countries in the world, there are internal armed conflicts in which thousands of people are being killed. In some of these conflicts, members of national, ethnic, racial, or religious groups are being attacked or murdered simply by reason of their membership in those groups. Human rights are under attack in these and many other parts of the world. The problem of irregular maritime movements of migrants has become a great challenge in a number of parts of the world, including in this region. With respect to the development of the international legal framework, we see that in some cases, some countries do not observe the commitments that they have made in the international treaties. And what's worse, in many cases, there appear to be no negative consequences that follow from their noncompliance. The lack of any negative consequences, the absence of an enforcement mechanism in international law, in most cases, even the absence of courts in which disputes about compliance with the law can be adjudicated, has called into question for some the effectiveness, indeed even the meaningfulness, of the international system that so many have labored for so long and with such commitment to bring into existence. And so I think the question, is the UN still relevant? And is the international legal system still relevant? I think it's a very fair question. Now, how would I propose to answer it? First, I would suggest that the United Nations is the only universal organization of general jurisdiction. If one country wants to interact with another country, the United Nations is an available and appropriate forum. In this sense, if the United Nations did not exist, it would be necessary to invent it. For many smaller countries, unable to afford the expense of embassies and a large diplomatic corps all over the world, the UN serves as a central forum for their foreign policies. The political institutions of the United Nations, primarily the Security Council and the General Assembly that I mentioned earlier, they reflect the political divisions in the world. Where they are ineffective, it is because member states do not agree on the way forward in a given case. And because those political institutions were structured in such a way as to limit the action that can be taken when political divisions are deep. Now, it's possible to regard those structural protections either as a structural defect of the institutions or as a safety valve that preserves the institution itself. But these structural features are a fundamental aspect of the system, and they should not be seized upon as a surprising or previously unknown flaw in the system. Now, also within the United Nations, and entities that I haven't yet mentioned, are the funds and programs such as UNICEF and the UN Development Program. Now, these are largely voluntarily funded entities that carry on important activities all over the world. They seek to be apolitical as they go about their work. They have contributed greatly to economic development, to global education, to the rule of law in developing countries, and ultimately also to peace and security and human rights. I should also mention the very positive results of the Millennium Development Goals and the current work on the post-2015 development goals, the Sustainable Development Goals. The offices of the High Commissioner for Human Rights and the UN High Commissioner for Refugees, within their respective spheres, also carry out important tasks on a daily basis in many different parts of the world. We should admit, I think, that one of the great achievements of the UN period has been the development of a universal human rights regime. Now, we're all familiar with cases in which human rights are not being protected. But what has changed from the past is that human rights are now accepted as a matter of international concern, and there is broad agreement on the fundamental universal human rights. The importance of the UN High Commissioner for Refugees becomes clearer every year as we see around the world conflicts which are increasing the number of people fleeing their homes. And I think we should also take note of the work of over 120,000 UN peacekeepers, police and civilians, deployed in 16 countries around the world, many seeking to provide security and stability in countries where there is no peace to keep. So how would I assess the United Nations? I would suggest that a full and considered assessment of the UN would find that it makes important contributions in all three pillars of its primary activity, peace and security, human rights, and development. But at the same time, I think we need to acknowledge that it is certainly not perfect, and it is not a panacea. How should we assess the contribution of the current international legal system? Well, first, I think we need to realize that international law is a constant and positive presence in our lives. Every time we make an international telephone call, take an international flight, every good that we import or export depends on the international legal system working effectively. Looked at over the long term, I would suggest that international law, despite its shortcomings that we've already discussed, has made very important contributions in areas like the resort to the use of force, international humanitarian law, and human rights law. Now, of course, there is still progress to be made. And since we're speaking this afternoon at a university and we have some students present, I would encourage some of you to consider taking on this work as your life's work, just as all of us here on the panel this afternoon have made it ours. So that concludes my remarks, and thank you very much for your attention.
Thank you very much, Mr. Mathias, for your presentation, for your thoughts this afternoon on the issue, the UN, the role of international law. So with that, let us move to our next distinguished speaker. Sir Michael, please.
Well, thank you very much indeed. I hope people can hear me through this strange object. Please shout if you can't. It's very good to be here. I'm very grateful for the invitation to be at this meeting and for your kind introduction. The title of the meeting seems to change every time I look at it. And I thought, therefore, I'd change what I'm going to say and begin by saying a few words about what's perhaps the most crucial area of international law and the one that is most testing, and that is the international law on the use of force by states. As you said, I was the legal advisor to the British Foreign Office from 1999 to 2006, so that was the 21st century. I prayed for peace when I took on the job, and was followed by a whole range of conflict. In each of these, I think international law played a very important part, at least from my point of view. The first conflict was the intervention in Kosovo. The second was following 9/11, the US-UK intervention in Afghanistan. And the third was the Iraq conflict of 2003. The Kosovo conflict raised a real issue of principle in international law, to my mind, whether there is a right of humanitarian intervention without authorization by the Security Council. The intervention in Afghanistan in 2001, I didn't think raised a major issue of principle. It seemed to me to be an exercise of the right of self-defense, albeit against non-state actors, Al-Qaeda, and that, it seemed to me, was fairly straightforward and fairly obvious. It wasn't retaliation for 9/11, it was to avert imminent further attacks from the same source. The third and most controversial of these conflicts, what I call the invasion of Iraq in 2003, to my mind, raised no issue of principle. Either it was authorized by the United Nations Security Council or it was unlawful. Whether or not it was authorized by the United Nations Security Council depended entirely upon the interpretation of a series of Security Council resolutions. That was a very difficult issue of interpretation, a very controversial issue of interpretation, but to my mind, it raised no issue of principle. And just to come back to these three events, Kosovo, the United Kingdom government justified it on the basis of an exceptional right of humanitarian intervention in order to avert an overwhelming humanitarian catastrophe. This was an argument that the United Kingdom had also used in 1991 to justify the establishment of the safe havens in northern Iraq, to save the Kurds of northern Iraq at that time, and also to justify the northern and southern no-fly zones in Iraq. Now that was a very controversial legal basis. It's one that the United States, as I understand it, did not agree with. They didn't really give any explanation of the legal basis for the action, other than what I call the accumulation of bad arguments. They came up with about 6 or 7 reasons, none of which, to my mind, amounted to a good argument. The United Kingdom was really at the forefront of this right of humanitarian intervention. And I have to say that although they have pushed it subsequently, it has gained very little traction. It was rejected by the non-aligned movement in the General Assembly in the debates in 2005. So that was a very controversial, but actually very successful military intervention. We then came to Afghanistan. As I've said, that was justified on the basis of a right of self-defense against further imminent actions by the terrorist organization. I thought it was pretty clear that there was a right of self-defense not only against attacks by states, but against attacks by non-state actors of a similar degree of seriousness as one might get from states. The International Court of Justice subsequently cast a lot of doubt on that in the Israeli wall in the Palestine occupied territories case, where they seem to be saying that the right of self-defense only existed under Article 51 of the Charter if there was an armed attack by another state. So Israel was not entitled to claim self-defense against attacks from the Palestinians in the occupied territories. But I still think, on balance, and subsequently the International Court has slightly drawn back from that, or at least not repeated it, there must be, it just stands to reason that there has to be a right of self-defense against a threat, a sufficiently serious threat from non-state actors. And then, as I said, the most controversial and difficult case was the invasion of Iraq in 2003. But that raised no issue of principle. I think everyone would agree that the use of force may be authorized by the Security Council, and if it is authorized by the Security Council, it is then lawful. The question was, had the Security Council authorized it? That required the interpretation of a series of resolutions, including the latest one, 1441. My own advice to the government, which is public now, was that it was not authorized and that the action was therefore unlawful, indeed an aggression. This advice was not accepted by our Attorney General. This is all public because we're having an inquiry that is still going on, but all the evidence is public. So that raised, it was very controversial, but not an issue of principle. The lesson I would draw from these three very serious events is that international law, at least for the British government, played a very major role in each of them. The British government would only act if it had legal advice to the effect that the action was lawful. In the case of Iraq, the head of the civil service and the head of the military made it clear to the Prime Minister that they needed a clear statement by the government's legal officers, in other words, by the Attorney General, that the action would be lawful or they would not feel able to take action. So whatever one may think about these events, they do, to my mind, demonstrate the importance of international law and its continuing relevance, even in the most difficult field of all, which is the law on the use of force. To change tack completely, and very briefly, I'll say a word about the United Nations International Law Commission, which is a subsidiary organ of the UN General Assembly, consisting of 34 individual experts who act in their individual capacity. As Steve Mathias has said, there is no central legislature in the international system. The UN General Assembly, under the Charter, is given the mandate of promoting the codification and development of international law, but only promoting it. There was a clear decision taken at San Francisco not to give the General Assembly legislative authority. And its subsidiary organ, the International Law Commission, likewise has the task of promoting international law. Just to recall very briefly the major fields of international law, I would say that 50% of international law, as you read it in the books, is now based upon the work of the International Law Commission. We could start with the law of the sea, where the 1958 conventions on the law of the sea were based closely on the work of the International Law Commission, and a lot of their key provisions became part of the UNCLOS, the United Nations Convention on the Law of the Sea of 1982. That would deal, for example, with such matters as East Timor's dispute, or Timor-Leste's dispute with Australia over the delimitation of the Timor Sea. It would deal with the South China Sea disputes, which are currently before an arbitral tribunal established under the Law of the Sea Convention. So the law of the sea is obviously a very important part of international law that is based on the work of the Commission. Similarly, the Vienna Convention on Diplomatic Relations and on Consular Relations, which are fundamental to diplomatic cooperation, diplomatic intercourse these days, were based closely on the work of the International Law Commission. The Vienna Convention on the Law of Treaties, so the whole of treaty law is now codified in that important document. Another one is the UN Convention on State Immunity from 2004, which codifies the restricted notion of state immunity. In other words, immunity only for acts of a sovereign nature and not for commercial activities. That's a very important convention, but I have to say it's not yet come into force. It has about 20 parties, and it needs 30, I think, before it will enter into force, but it's still regarded in a lot of courts as largely reflecting customary law. The Commission also did the first draft of a statute for the International Criminal Court and a whole series of other important texts. But is it still relevant? It's often said that all the major areas of international law have now been covered. That's actually not true. There are important areas like jurisdiction, which have not yet been codified. It's now less and less dealing with provisions that could become treaties, and more with guidelines, principles, conclusions. what might look more like soft law or may contribute more to customary law than to treaty law. That's not really what was initially intended, but it's still dealing with treaty matters. And for example, we have an item on the agenda at present dealing with crimes against humanity. The idea is to prepare a draft of a convention on crimes against humanity, which could then be adopted by states. As you know, I'm sure there are 4 core international crimes in the jurisdiction of the International Criminal Court: genocide, war crimes, crimes against humanity, and the crime of aggression. And there is already a convention against genocide. There are the Geneva Conventions dealing with war crimes. There is nothing whatsoever dealing with crimes against humanity except certain specific cases such as torture. And so it would, in my view, though this isn't universally accepted, fill an important gap if the Commission could stimulate states, and I think they need a bit of pushing into adopting a convention on crimes against humanity. There's a very important topic on our agenda, which is about the immunity of state officials from foreign criminal jurisdiction. When is a head of state who may be accused of one of these core crimes immune from the jurisdiction of a foreign state? When is any state official immune from the jurisdiction of a foreign state? This is an issue which foreign ministries are faced with constantly. There's more and more activism on the part of NGOs and others trying to bring to justice those who they believe or they think may have committed some of the most serious crimes, and they go around the world trying to bring cases against senior officials and others. This is a very difficult issue. It would be very good if the International Law Commission could make proposals to states for what the law should be on that subject, but I think that's going to be very difficult indeed. The Commission has already agreed that heads of state, heads of government, and foreign ministers should have personal immunity, complete immunity that is, during their term of office. But what about after they've ceased to hold office? And what about other people other than the so-called troika of head of state, head of government, and foreign minister? Should there be exceptions? Should the general principle that you have immunity for official acts, immunity in foreign courts for official acts done on behalf of the government, be subject to any exceptions? Should it be subject to exceptions for genocide, war crimes, crimes against humanity, which is what the UN High Commissioner for Human Rights came and told the Commission a few weeks ago? Quite a lot of us actually disagree strongly with him and believe there should not be such exceptions. But that's going to be a very controversial matter in the Commission. I think I'll stop there. I hope I've said enough to show that, in my view, international law is still relevant, and the UN, in all its various aspects, is still relevant to international law. Thank you.
Thank you, Sir Michael, for sharing with us the 3 cases, as well as deliberating a bit on the UN International Law Commission and its work. So let's us move on and listen to our Professor Rahmat with his take on this particular topic.
Thank you, Madam Chair. Assalamu alaikum wa rahmatullahi wa barakatuh. And a very good afternoon. Excellencies, the Deputy Vice Chancellors, my colleagues, ladies and gentlemen. I firstly would like to thank the organizers for having invited me to make some or short presentation on the topic of the role of United Nations and international law in the 21st century, whether it's still relevant. what would be my thinking of these two institutions, the United Nations and international law? I would like to say this to begin with. Can we imagine the world without United Nations? Can you imagine the world without international law? Where does the states air their concern, their grievances on matters of common concern or international concern? Where will the bilateral and multilateral dispute be resolved if you do not have a proper forum? So obviously, the United Nations as an important institution has played an important role, and I think will continue playing that role in the 21st century. And I think without doubt, all states would agree that it has contributed enormously in many aspects of human life. Now, what about international law? I mean, if you are a student, a law student, taking the subject of international law, you would ask this obvious question, whether international law is enforceable. How do you enforce international law? How do you make, for example, a strong state to fulfill the obligations that suppose they become a signatory to a treaty and they defy the treaty? When we have a very important maxim in international called Pacta sunt servanda. How do you force these states? In many instances, we know that there are a lot of defiance of international law. So what would be the mechanism to ensure that all states would observe and respect international law, even to a certain extent that when a state had defied international law, the state will still say that we respect international law, we uphold international law. So this is, as my colleague said, it is a paradox really, that one, you say that you respect, you honor international law, at the same time, you fail to observe international law. So how do we enforce it? We do not have the enforcement mechanism. One cannot compare the national or domestic enforcement, like the courts, as to international law or United Nations. You will not be able to resolve the issues if you start comparing these two entities. But what we have, I would like to say this, that first, we have this inherent shortcoming or the traditional complaints that there is no enforcement agency to ensure that all states would observe, would respect international law. But how do we remedy it? How do we ensure that states at least observe international law? I think it will be not, the answer will not be in the law itself. I think the answer is through goodwill, through political will of the states, that eventually they will respect and observe international law. Now, the smaller states, the weaker states, always say this to the stronger state, that we acknowledge your superiority, but we would like you to observe and respect international law. So these are things that has been said. The mantra in many resolutions, in statement made by the smaller states, urging the stronger state to observe international law. So it is very much the political will, the goodwill, that we hope that these stronger states, the powerful state, to observe and recognize the importance and significance of international law. So it is not a legal basis, but rather a moral basis to implement the international law on the ground. Thus, the biggest challenge, therefore, I thought, is to persuade all countries to observe, to respect international law. And my second point is in relation to how relevant is international law. I would like to say a bit more about my organization, the Asian African Legal Consultative Organization, or well known as ALCO. Many of you, I suppose, are not aware of the existence of this organization. It has 47 countries as members of this organization. It is, the Secretariat is in New Delhi since 1956. It is, in fact, a tangible outcome of the Bandung Conference, which was held in 1955, that at that time, the new independent states thought best that they should have a forum, so to speak, an international organization that would provide this platform for newly developing countries or independent states to come up with ideas or common concern that they could air in international forum, or to bring those issues to United Nations. So you have this organization, and it is important that this organization, in its statute, which says that the organization promote progressive development of international law. Progressive development of international law is, I think, the main objective of this organization, to ensure that at least the concerns of Asian and African states are being heard in international forum, and the fact that we are also a permanent observers in the UN, in New York, Geneva, and Vienna, give us that platform to carry out the mandates of the Asian and African countries, to tell the other counterpart that these are the concerns of the Asian and African states in relation to environment, trade, human rights, so on and so forth. And one of the important tasks of this organization, of course, is to have a closer cooperation with International Law Commission, of which Sir Michael Wood is a member of that commission. And since its inception in 1956, ALCO has playing that important role. First, to gather all the feedback from member states relating to subject and topics of ILC. And as Secretary General, I will make a yearly visit to Geneva, and to have a discussion and deliberation with all the 34 members of the ILC. In fact, the presence of Sir Michael Wood, as an eminent member of ILC, and also Mr. Stephen Mathias, is a testament that international law still relevant and important to the whole community, or to the international community. So that shows that we are working closely. In fact, I had the privilege of inviting both of them to come to Malaysia. As far as Mr. Stephen Mathias is concerned, this is his first visit to Malaysia, and we had a 2 days important discussion on a subject of customary international law. This is a very important subject. Now, as claimed by many developing countries, that they are not a party. They do not have a privy to the making of customary international law then. As you know, that international law is now 300 years old, and at its inception, none of the developing world, Asian and Africans, are parties or privy to that making of customary international law. So it is important, therefore, I reiterate and stress that the participation of developing countries of Asia and Africa is most eminent. Now, if you say that you are not a privy to the making of customary international law, now it is the best chance that you have to ensure that you have your mark and to have your say in the development progressive development of international law. Now, we cannot avoid the application of customary international law. As you know, that customary international law is one of the sources of international law. This is the best opportunity that countries of Asia and Africa participated in this topic that has been introduced by Sir Michael Wood. I took the initiative to establish an informal expert group among the experts of Asia and Africa. We had several meetings and we have come up with a report responding to what Sir Michael Wood, the special rapporteur on the subject, had written in the report. This is very important. And I think we had a very successful meeting and we hope to proceed further. And we hope, as a secretariat, we hope that the member state would agree at least to endorse and acknowledge the importance of this topic, customary international law. So there you are. If you say that international law is irrelevant, then I would strongly disagree with you, that I think developing countries have a role to play. In fact, what has been said by Sir Michael Wood, that the work of ILC in relation to law of the sea, in relation to immunities, in relation to diplomatic and consular, all those are relevant, and in all those topics, I think ALCO had made a significant contribution. For example, in law of the sea, when it started the discussion of formulating UNCLOS or the UN Law of the Sea Convention, ALCO had contributed in the sense that we came up with the idea of the EEZ and the importance of straight states and their rights and entitlement and their obligations. So we have contributed and we will continue to contribute. And the last point is in relation to the challenges. This is very important. I think the two speakers had mentioned about the importance of the emerging topic like cyberspace and international law. How do you deal with cyberspace? This is a new topic, and many states and government are grappling to understand the application of cyberspace. The other aspect is violent extremism and terrorism. This is another aspect that government are grappling. Government try to understand, and what make it worse is the status of non-state actors. Who are these? How are they going to be responsible? At the moment, we only take care of the states. But what about non-state actors? So they are equally responsible in the killings and massacres of innocent life. So where do you put non-state actors in the wide, in the paradigm of international law? So these are new topics that ALCO is pursuing. And as I said, ALCO works closely with United Nations and with International Law Commission. And we hope that at least in relation to progressive development of international law, we are able to contribute to the member state of Asia and Africa widely. So with that, Madam Chair, I would stop here, and perhaps if there is any question, I will take those questions. Thank you.
Thank you very much, Prof. Rahmat, for sharing with us on ALCO and its, the role that it plays, as well as, of course, the question that you pose. What would the world be like without United Nations or without international law? What do we do? How do we resolve disputes between us, not having mediation and so on? So I would like all of us to give a round of applause to our distinguished speakers.
Sir Michael Wood. And Professor Rahmat.